Do you see the situation you're in? Okay, well, a vehicle, actually several vehicles were struck, okay? You guys took off. Yeah, no, you're driving, correct? Okay, you're in the car, correct? So you guys took off, struck a guardrail, probably nearly hit several more vehicles. Okay, hurry up. Put your bra back on and step out.
Okay.
On March 15th, 2026, body camera footage captured a DUI investigation following a multi-vehicle crash and hit-and-run in Florida. This analysis examines the constitutional protections, Florida statutes, and tactical standards that governed every phase of this encounter.
Charlie, keep on close line. Repeat copy, 28. Out of Florida, Zulu 82, Alpha Golf Uniform, ZA2 AGU. Occupied by a white female. And a white male. Step out.
Confirming a white female and a white male.
10-4 and it's possibly signal 2.
Copy. Possibly signal 2.
Do you see the situation you're in? Okay, well, a vehicle, actually several vehicles were struck, okay? You guys took off. Yeah, no, you're driving, correct? Okay, you're in the car, correct? So you guys took off, struck a guardrail, probably nearly hit several more vehicles. Okay, hurry up. Put your bra back on and step out.
Okay.
Yeah. No, you got about 5 seconds before I take you out.
Step out.
Put her bra, it's upside down.
Alright, listen.
10-4 comes back.
Oh, good.
Negative to William McDaniel, 47 Lloyd Road.
Yeah.
Why are you driving?
Hold on. Are you gonna, okay, stop for a second. Are you gonna put her bra on, yes or no?
George, select me around.
You need to take it off?
Unit on citation from
Well, I need him to help put her thing on.
and target.
It's completely upside down. She needs to remove it, turn it up. It needs, she needs to take it off and flip it upside down.
How can I help her put it on?
Can you help me?
Okay.
Here we go.
Alright.
Can you help me?
Do you have a shirt at all? Do you have a shirt in the car?
Yes, sir.
Okay. Walk over to the side.
2.3
Stand right there. Okay.
10-4, just for your 14, we do have call history. I looked up the tag. The previous 22 Delta. Delta carry signal 0. Also, advised information regarding an LEO.
Charlie 224, I copy. Also show whiskey. Fuck grab the team. Yeah. This one's gonna make some money. Do you have shoes in the car? That's, yeah. You got it for a second?
Anyone here at the original crash site, or is somebody already there?
Hey! Hey!
I don't know if anybody made contact with
I
the original
did.
crash scene. All 3 units are
Call
connected
it
to
up.
the signal 2 subjects.
If you want me to do that,
I'll be around. 10-4, thank you.
Alright, you got anything on you? Any weapons?
No.
Narcotics? Anything that's gonna stick me or prick me?
No.
Thank you. Thank you, sir. I saw it on my way here. I was...
Hey! Awesome!
Alright. You can have a seat. Where's your shirt?
In the car, buddy.
Alright. It's gonna take a second to
It's
find the
okay.
shirt.
He's so awesome that I'm gonna try to call you. Daddy.
Yeah. Cheers.
She the only one involved? Or?
He's passenger. She's driver.
Master, I'm Daddy. Wait, can I just contact with you, Daddy?
Not yet. And I don't know if you saw from down there. There's like 4 cars hit the guardrail, booked it up here. There's like, I don't know if any of these cars got hit, but I don't know where to begin right now.
Baby!
Okay, Marina. You can have a seat there. I'm gonna ask you I'm gonna read you your rights, okay? These are your Miranda rights.
Real quick though, we are done. Stay on the car. We're done with the crash portion of everything we have to do.
Yes, sir.
All right. So we're gonna now switch over to a DUI investigation. Okay. She's gonna read you something.
You have the right to remain silent, and anything you say may be used as evidence against you. You have the right to talk to an attorney and have him or her with you now or at any time during questioning. If you cannot afford an attorney, one will be appointed to represent you. If at any time you wish to stop talking or have an attorney present, all questioning will be stopped at your request.
Yes, sir.
Do you understand these rights?
Yes.
Okay. With these rights in mind, are you willing to talk to
Yes.
them? Okay.
If we take the handcuffs off over here, will you be willing to
Yes.
submit some field sobriety exercise
Yes.
if you can?
Yes.
Okay. We'll give it a shot. We're gonna come over here in front of the car. Well, let's see how it works.
Sweat, yeah. Okay. We'll go up on that cement portion. Watch your step here. Okay. Stop right there. I'm gonna take these. Yeah. Do you want to just move the rocks a little bit? I also have duct tape in my car. So. Don't go anywhere.
These are Citation Boulevard. Check.
Okay. Huh? Yep. Yes, please.
Sorry, Charlie 313, contact 216, stand right there.
Okay. Stand right here. Okay. I'm gonna check your eyes, okay? Keep your feet together, so step with your feet together.
Charlie.
Oh, get it. You're okay. Can you put your feet together? Like this?
Charlie 223.
Can you notate
Alright, I'm going to check your eyes. Keep your feet together and your hands at your sides. Just like that. Keep your head still and follow this pen with your eyes on your eyes only, okay? Do not move your head. Okay? Can you point to the tip of the pen?
Contact 216, Charlie 313, fast check.
Can you point to the tip of the pen?
Copy.
You can point. Good. With your finger.
Sorry to be 22, fast check.
Okay, we'll begin.
Copy.
Okay. Good. Alright, so now we're going to do the walk and turn, okay? So you see this line right here?
Yeah.
Watch it. Yeah, put her back. Okay? Stand with your feet together, your arms by your side. Alright. What you're going to do is you're going to place your right foot directly in front of your left foot with your heel. Let me explain something. Alright. So keep your feet together while I complete the instructions. Don't move until I tell you to do so, okay? So put your feet back together. Put them like this. Okay, we're calling it.
Put your hands behind your back.
No worries.
No.
Alright, let's go back to the car.
215? I'll call for it.
Alright, watch your step here.
Don't mind driving through. I got it. What we'll do is let her get out of here first before we take him out of handcuffs. That way she's out of the scene. I got it.
Yep. So you want your phone with you, right?
Yeah.
And it's in that. It's in the fishing bag in the front.
Yes.
Okay.
Can someone
What else do
I
you
want to call me.
need? Your phone, and what else do you need?
Call me daddy.
Okay.
Under the Fourth Amendment, a traffic stop requires reasonable suspicion based on specific, articulable facts. An arrest demands the higher standard of probable cause. Here, officers possessed probable cause well beyond either threshold: a fleeing vehicle, a damaged guardrail, and at least 4 other cars struck in the process. This satisfies Terry v. Ohio's 1968 standard and aligns with Navarrete v. California, which held that even anonymous tips about dangerous driving can justify a stop. Upon contact, officers observed the driver wearing her undergarment inside out and barefoot. Under established DUI case law, disorientation with basic tasks is a recognized indicator of severe cognitive impairment. These observations, combined with the crash evidence, gave officers more than sufficient probable cause to transition from a crash inquiry to a criminal DUI investigation. The Miranda procedure here deserves particular attention. Under Berkemer v. McCarty, 1984, ordinary traffic stops do not constitute custody for Miranda purposes. However, when the situation escalates to the point where a reasonable person would not feel free to leave, custodial interrogation begins, and Miranda warnings become constitutionally required. The officer explicitly announced that the crash portion was complete, and the investigation was now shifting to DUI. Miranda was read at exactly this transition point. This is textbook procedure. All 5 components were delivered: the right to remain silent, the evidentiary use warning, the right to counsel, the right to appointed counsel, and the right to stop questioning at any time. The subject confirmed understanding and consented to speak. This creates a clean evidentiary record that would be extremely difficult for a defense attorney to challenge. Turning to the field sobriety exercises, under Florida law, these exercises are voluntary. The officer properly framed the request as an offer, not a command, and the subject's consent was recorded on camera. The horizontal gaze nystagmus test was administered in compliance with NHTSA protocol. The officer instructed the subject to stand with feet together, follow the pen stimulus with her eyes only, and keep her head still. HGN is the most scientifically validated of the 3 standardized exercises, with a reported accuracy rate of approximately 88% when administered correctly, according to NHTSA research. The walk and turn test revealed critical evidence. The subject could not maintain the instructional stance, began moving before being told to start, and required the officer to restart instructions multiple times. Under NHTSA guidelines, each of these behaviors is scored as a separate clue of impairment. The subject then verbally refused to continue the test, which constitutes an additional indicator. Florida courts have consistently held that an incomplete field sobriety exercise due to the subject's inability or refusal remains admissible as evidence of impairment. Now to the applicable Florida statutes. The primary charge is DUI under Florida Statute Section 316.193. This statute defines DUI as operating or being in actual physical control of a vehicle while impaired to the extent that normal faculties are affected, or with a blood or breath alcohol level at or above 0.08. A first offense carries a fine of $500 to $1,000 and up to 6 months in jail. If the blood alcohol concentration exceeds 0.15, the penalties increase to up to 9 months. The second charge is leaving the scene of a crash involving property damage under Florida Statute Section 316.061. This is a second-degree misdemeanor carrying up to 60 days in jail. If any occupants of the struck vehicle sustained injuries, the charge escalates under Statute 316.027 to a third-degree felony, punishable by up to 5 years in state prison. An important development in Florida DUI law is Trenton's Law, House Bill 687, which took effect on October 1, 2025. This case occurred after that effective date. Under Trenton's Law, a first-time refusal to submit to chemical testing is now a second-degree misdemeanor criminal offense, in addition to the existing 1-year license suspension under the implied consent statute. This represents a significant shift. Previously, refusal carried only administrative consequences. Now it carries a criminal record, fundamentally changing the calculus for DUI suspects. Evaluating the use of force under Graham v. Connor, 1989. The Supreme Court established that force must be judged under an objective reasonableness standard. 3 factors apply. First, the severity of the crime, DUI, combined with a multi-vehicle hit and run, is serious. Second, immediate threat. The subject had already fled one crash scene. Third, resistance. The subject verbally resisted and refused to complete testing. The handcuffing and arrest were objectively reasonable under all 3 Graham factors.
Charlie, keep going.
As long as you cooperate.
Everything's okay.
Okay, be careful.
Everything's okay.
I'm sorry. When you get inside, yeah. Inside, not right here.
For the officers, we are assigning a grade of B+. Constitutional compliance was excellent. Miranda timing was precise. FSC administration followed NHTSA standards. The pat-down was professional, and the tactical decision to separate the 2 subjects before transport demonstrated strong situational awareness. These are the marks of well-trained officers. The deductions reflect a slightly aggressive verbal warning early in the encounter, and the absence of an audible implied consent warning in the available footage. For the subject, Marina, the grade is F. She operated a vehicle while severely impaired, struck multiple vehicles and a guardrail, fled the crash scene, and directed profanity at officers. The only mitigating factors are that she consented to testing, did not physically resist arrest, and expressed concern for her child, suggesting some residual awareness of consequences. For the department, we are assigning a B. Officers demonstrated solid DUI investigation training and Miranda compliance. Bodycam footage provided full transparency throughout. Lesson 1 for law enforcement: the explicit verbal transition between crash investigation and DUI investigation, with Miranda delivered at the pivot point, should be standard practice in every department. This single procedural step protects the suspect's constitutional rights, preserves the integrity of the prosecution's case, and creates an evidentiary record that withstands appellate scrutiny. Lesson 2 for drivers: leaving a crash scene does not eliminate the problem. It adds separate criminal charges under Florida Statute 316.061. Those charges escalate dramatically based on whether anyone was injured. A property damage misdemeanor becomes a felony the moment an injury is involved. Lesson 3 for the public: if you observe an impaired driver, call 911 immediately. The early Signal 2 dispatch in this case allowed officers to locate the vehicle before additional collisions occurred. Lesson 4 for the legal community: Trenton's law has fundamentally changed Florida's implied consent framework. Defense attorneys and prosecutors alike must adapt their strategies accordingly. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to the channel for even more police interaction and courtroom content.